and welcome to the Law Center videocast. I'm Larry DeMarco, your host and founder of the Law Center. I produce the Family Court Custody Bootcamp, an online program that's revolutionizing family court for self-represented litigants. Learn more in the description portion of this video. Thank you everyone for joining us today. Please subscribe to the channel, like, share, and comment, which enable more people to learn from the Law Center videos. Today, we're here with Rael Lapenta. She's the co-founder of Interference with Child Custody Coalition, an advocacy group seeking to enforce criminal laws that ensure adherence to custody court orders. Rael, thank you for being a guest on the Law Center videocast.
Hi, Larry. Thank you so much for having me here.
So how did you get into advocacy for changing laws and enforcing custodial interference?
It unfortunately happened with my own case. I came into a situation where I had custody. It was 50-50, and my ex had kept my daughter. And so I had called the police thinking that they would help, and they said it was a civil matter. And it seemed like every turn I went to, it was being told that no one could help me. And I just am a little stubborn that way and didn't want to take no for an answer. So I found a way to just keep pushing. So now I work with teaching other parents things about custodial interference and talk to legislators about amendments. So the changes in my case weren't obviously immediate, but it was a way that I felt like I had some control in this situation.
As a family law attorney, I know the traditional way, petitions for contempt to enforce custody orders, which is, as you say, what police officers say, go and do. They don't want to get involved. However, I know firsthand, of course, that it's slow, costly, and often ineffective because judges don't always want to get involved either, or the punishment's so light that it's not really a deterrent. So what alternative have you found to enforcing an enforceable custody order, and tell us what law that applies?
So there is actually a criminal law in every state. So the civil route is when you go to family court and you have an attorney and you have put a petition in, and then there's also, you can go criminally. So if your car is stolen and you call the police, they will take an offense report and they will investigate the crime, and you don't need to get a lawyer. You just as a victim. So there are laws in every state, and most states it's a felony for custodial interference.
So the problem is that there's an enforcement issue because the officers who are supposed to know this opt not to get involved and say, take it to civil court because there's that civil remedy, correct?
Yeah, and I think that officers feel like they're going to be determining a custody dispute. I think there's a lack of training there, and sort of like they don't want to get involved in the he said, she said. The facts are different. It's black and white. Either you have custody or you don't. But we've been told by police officers that they don't want to throw a parent in jail if they're 15 minutes late. I think that they just look at it as tit for tat, I guess, and they don't want to get involved. And they definitely don't see the danger in one parent keeping a child.
So in those situations where you're a parent, you have an order and the parent is just saying, go pound sand. I know it's going to take you 9 months to a year to get in court. I'm keeping the child and you're not getting him or her. Take us through the steps that you recommend to have the best chance at receiving help from law enforcement, and feel free to use the presentation slides that you prepared.
So all of our information, all the information that we ever do is from an official source. So from the slides here is from the National Center for Missing and Exploited Children, who have created several amazing law enforcement policy and procedures for reports of missing and abducted children, for family abductions, for custodial interference. The guides are there. For the NDAA parental kidnapping compilation is a document that has every custodial interference law in each state listed. And the OJJDP, which is the Office of Juvenile Justice and Delinquency Prevention, has statistics and definitions. So to enforce this law, from people that have done it before, and we think it's important in this issue to not reinvent the wheel. So we openly and freely give out this information to parents and tips and tricks, I guess, for things to prevent and know for better odds to get this enforced. So according to the National Center for Missing and Exploited Children, what is custodial interference? Family abduction occurs when, in violation of a court order, a decree, or other legitimate custodial rights, a member of the child's family or someone acting on behalf of a family member takes or fails to return a child. It's also referred to as parental kidnapping and custodial interference. Custodial interference is not a civil matter. Civil matters are things that are private matters. You need to have a different preponderance of evidence. You have your own attorney. And the criminal law is a public wrongdoing. You're prosecuted by the state, and victims don't have to put on the case. So these are the penal codes for every state. For example, here's Pennsylvania. So the penal code is 2904. So in Texas, 2503. You could type that in, Google it. You could even Google your state and just say the custodial interference law, but know this penal code first.
Gotcha.
So a step-by-step guide to reporting. First, identify what law enforcement agency has jurisdiction over your exchange point. So if your custody order says that you pick up at 6 o'clock at McDonald's, then you go to McDonald's at 6 o'clock and you know ahead of time which law enforcement agency has jurisdiction over that McDonald's. You call 911 from the location and report the violation, saying, I would like to report a crime. Many dispatch have been trained already to, if they hear something on custodial interference, to put it in as a domestic disturbance or an incident versus an offense. So it's important too, when you're calling, to say it, initially right away, I would like to report a crime.
So just to jump in on that, you are saying that you are aware that dispatchers are trained contrary to the law, or trained not to enforce this.
Right. Yes, we've seen the training. We request that through policy and proceed, like open record requests, that we've seen them.
You've done that, and you've seen the differences or the problems with the training that preclude proper enforcement of this. And you are telling our viewers, don't accept just a report over the phone, but to ask for the officer and say, you need a report of a crime and offense report.
Yes, and someone has to come out.
Now, while I'm here interrupting you, which I apologize for, these bullet points, did you get these from this website or did you adapt them?
No, I work with Claudio Valles, who really started this movement and found out that this was the law. So she has reported custodial interference, and this is things that we've learned from research and speaking with legislators and speaking with police officers, and we talk to everybody about it. So it's sort of things we've learned.
These bullet points are your research, not on the site. Okay.
Yeah, no, not these steps.
Well, continue then. Thank you for sharing this with us. Go ahead.
Yeah. So ensure that you do not deviate from your orders. So, if you come at 6:30, that is going to be less of a chance that they would enforce custodial interference.
Sure. When you say your orders, you mean the written agreement. Be sure that you have the actual order and that you follow it to the letter, correct?
Yes. The judge signed order. And if you can get a sealed stamp on it, just from the courthouse, that's sort of verifying that this is the most recent one, that is ideal. If you think that you're going to be denied, you can always call for a courtesy standby. So you can call the police and say, I'm supposed to pick up my child and I anticipate that there's going to be a denial. Can you have a courtesy standby, or can you come with me for the pickup? Know the law, the penal code, like we were saying, cite the law. Have the law printed out, because many law enforcement don't even know that this is a law. Prepare yourself in advance and just stick with the facts when reporting the crime. Leave the court drama and emotions out of the conversation. The second you start saying, he's always going to do this or she never lets me, you're going to lose the point. It's hard, and you stay neutral and just be prepared to ask questions of the police officer regarding just the law and your custodial time. Be certain that the officer's body cam is on to record the reporting. If you are a one-person consent state, then you can record it as well. If you are a two-person consent state, then you can't record that unless everybody approves. But it's good to have it on recording, have a witness if possible, and be sure to get the officer's name, badge number, and supervising officer. It's very important to have these details, and very often, you get heated in the moment and you start talking and you forget to get that information. It's very likely that you're going to leave the scene of the violation without your child. So prepare yourself for that, remain calm, and be respectful when asking if you are being denied your right to report a crime. You can request for that to be put in your report. So you want to ask for an offense report, which is for a crime. A lot of times they'll give you an incident report, which basically they're just documenting what happened. And you can say, can you please document that I'm being denied my right to report a crime? Even if you're denied, request a report number.
Let me
or
clarify.
a copy.
You are saying you're going to be denied a right to report a crime if the officer calls it an incident when it is in fact an offense in crime.
Yes, and you want that in writing, because at the end of this, if you continue to be if this law isn't enforced, you can then put in an internal affairs report, and you've been creating a paper trail.
Excellent. So if you're denied, request a report number.
Yeah, get a report, find out how you get a copy of the report. You want an offense report, but whatever kind they're going to give you, don't leave without some kind of documentation. Understand that the law enforcement deems these issues as civil and is unaware that a penal code exists. If needed, ask for a supervisor to elevate the reporting process, and again, get their names and badge numbers. It's so important to keep your cool. And it's so hard to do when this is happening to you. But the second you start getting excited and if you start getting defensive or aggressive, it's going to dramatically decrease any officer's willingness to work with you.
Rael, I have a question. Do you know of anyone else who's promoting the enforcement of this other than your advocacy group? I am humbled to say I was not aware of this one going through, notwithstanding that I'm a practicing attorney. I've never had the moxie or the aggression against the system to insist, to tell the officer this is a crime, report it. Things could have gone a lot easier for me and other parents. Do you know, again, my question is, do you know of anyone else promoting this to the level that you are?
No one else is crazy enough to push this, but it's your right. And so we don't say go and get aggressive, but you can ask questions. So when they say, I'm sorry, this doesn't count as a parent, you can just say, well, can you show me where it says that in the law?
Sure.
Please.
Yeah. Maybe aggressive was the wrong word. It's more assertive, rightfully assertive in a positive way. So thank you for that part of the presentation. What amendment have you promoted in Pennsylvania?
So I'm so excited about that. The custodial law in Pennsylvania said that if you take a child, that if you don't have the legal custody ability to do that, then you are engaging in, a custodial interference. So there was bad case law, we were told from the DA in Bucks County, that a Supreme Court had said, if you say that you feel like your child is in danger, it doesn't have to be a reasonable fear. That's an excuse, a defense. So we got all that information ahead of time, and we sort of put in safeguards there with the amendment. So it's going to be filed in the fall, and it's changing the age of consent from the child from 14 years old to 18 years old. which is huge. We don't know any other state that has 18. I mean, that's huge. It also has a required training program. So the state police in Pennsylvania do have a policy, and they charge about 3,000 people in the past 5 years for custodial interference. But no other jurisdiction, no other municipality has a policy. So they are not enforcing this. So there's only been 126 cases in Pennsylvania ever sentenced since this law was enacted in 1972. But the state police had charged 3,000, and they only have jurisdiction over like 11 counties out of 67 because they have a policy. So the amendment includes Pennsylvania State Police training all police departments and creating a policy for them. It also includes safeguards for if you do feel like your child is in danger, you have to call the police before you keep the child. You can only keep them for 24 hours.
Fantastic.
And you have to call CYS. And mandatory makeup time. Once you go to court and say like they kept them, mandatory makeup time, as well as upping the statute of limitations from 2 years to 5 years.
So how did you go about getting this amendment sponsored, proposed, and on the move? What did you do? Describe how you got here, and what is the current status?
It's already circulated, so legislators are off for the summer, but so they don't. Some do file anything, but nothing will happen until they go back into session in September. And it's ready to go. It's circulated to stakeholders, and it's gone through all the steps. And
do you know
so
what votes? Filed. Do you know what support? Was there a poll, or do you know what support there is in each chamber?
Any legislator that we've spoken to has totally understood it. I mean, we have not had one person, and we've talked to hundreds, that have ever been like, I don't think that's a problem. So we are going to go to the Capitol in September to sort of, a bunch of parents will go, we'll have flyers, and we'll put the information out about custodial interference. The numbers are there. San Antonio has 1,000 calls per month on custodial interference. Pennsylvania's whole state in 50 years has ever sentenced 126 people. I mean, you can't deny it. It's bottom line.
So the state police in the 11 of the 67 counties have been charging, but of that 3,000, only 100 and some. So a small, minute fraction ever enforce it. So it's just used kind of as a threat without teeth.
But if you got your kid back,
right,
would it be helpful?
Sure.
And the police are doing their job. The next step is the district attorney, who is not doing his job by enforcing this.
And again, we're only talking about those 11 counties. There's no policy in any of the districts with local police enforcement, correct?
Right. And I didn't know you needed a policy. I thought police read laws and enforced them. That doesn't happen. They need a policy saying what to do. In Philadelphia, there was an issue with squatters where they would call the police, and the police would always say this is civil, and they would send them back until the district attorney was told by the attorney general, said, tell your police, ask for the deed. This is the policy, ask for the deed. If their name isn't on them, arrest them. And now squatters are arrested in Philadelphia because they say, look for the deed. But without that policy, that did not happen.
So this is a big part of what you're doing. You're trying to change policy so that the districts enforce this law that enforces custody.
We're trying to get every angle. Like, we literally are trying to find anything that was a barrier. We've tried to put that in that amendment. The training is going to be in there, which will be huge. The makeup time is even an incentive. That's going to be a consequence for another parent to not keep a child. Right now, there's none. There's absolutely no fear of a consequence for a parent to just keep a child.
Thank you for sharing that excellent presentation. You also gave a presentation at the Parental Alienation Study Group Conference in Colorado last month. would you share the concerns that you have with the national effort to pass Cadence Law in every state?
Cadence Law. It's based on the VAWA Stop Grant. So in 2000,
And that's an acronym for Violence Against Women's Act, correct?
yes. And in 2022, it was reauthorized and the language was changed. And they say things like you could get up to $5 million in your state if you pass the specific language. So states are highly incentivized financially to pass this kind of legislation. Unfortunately, it's not working out, obviously, as people would think it would.
Why is that? Be specific.
So there's certain things in the federal language that you have to enact in your state law. And if you do not, you're not going to be eligible for funding. We've talked with the APA, who was, I guess, in managing the grant or distributing the grant. And they said the average that actually is being distributed is $273,000 or something, not the $5 million or $23 million that people think that they could get from passing this legislation.
Can you explain with the acronym? People, our viewers don't necessarily, all of them don't know the acronyms that you're using. Who is the what something A? We spoke to find out.
APA.
What's the APA?
Or ABA, I'm sorry, the Bar Association.
Oh, okay, the American Bar Association. Gotcha.
I said P, so of course that's even more confusing. It was ABA. And so, you know, that's something we do all the time. We just ask questions of everyone. So we went and we said, okay, who's giving out this VAWA money? Is people really going to get, states going to get actually the amount of money that they think they're going to get? And the answers we got were no. And that you have to have all of the language from the federal bill. So far in every state that this legislation has come to, luckily it has died because it hasn't been at a place that would have protected all children. In Colorado, they did just pass it. And it's concerning, some of the language that's in there, and it's not the language that's in the VAWA. So it's definitely going to be interesting to see what kind of financial revenue comes from this grant. They're assuming it's a lot. This was I think $125 million fiscal note on this legislation. So
please describe the concerns that you have with the wording as written, what the lobbyists are trying to pass across the country, the model language they propose. What are the concerns?
Yeah, so in the VAWA law, it says that you have to have training, which obviously is positive. The intention is to protect domestic violence victims, but it's almost like they sort of threw in child abuse as well, but really only child sexual abuse. So it's excluding psychological abuse. So, for example, one sentence would say, you cannot ever remove a child from a parent unless they are physically or sexually abusive, which is leaving out psychologically abusive. So if in court it's found that the parent is psychologically abusing the child, the judge would not be able to remove that child for the child's protection, for a time for that parent to get help. And in California, for example, where it said that in this law, there's more psychological abuse than any other type. It's like 8 or 9% of psychological abuse happening in California, 7% physical, and 5% sexual. So the bill there would only protect children if they're physically and sexually abused. Some other language in Maryland, it said that parental alienation is invalid and it is not allowed to be used in a custody hearing. In Colorado, this law definitely seems to motivate parents even more to put a false allegation in. There is several steps that need to happen. As soon as you are just accused, of abuse in a family courtroom. So not with CYS, not with the police, but you would have to acknowledge your responsibility. The judge would only be able to look at the accused party's actions. The domestic violence groups would have to approve your mental health professional. You would have to agree to meaningful therapy for over a year. And that's probably most of them, but that's some of the steps that would happen if another parent just accuses you of abuse. So those are major concerns.
So it's a law that is incentivizing and encouraging false allegations because of the powerful effects it has in court and the negative consequences against the accused just for being suspected of doing something.
Accused, yes.
So this is your advocacy time. What do you do professionally?
It takes up a lot of time because it's important, I think. But I am a behavior and sensory therapist. So I'm an RDI consultant. I have my own practice, and I work with families with children with special needs or behavior issues. If they, to get them back in school or make things work in schools.
So if you are listening to these great techniques and this other way of working outside the civil system, if someone would like advice on how to do what you're doing in their state, how can they reach your organization?
Yeah, please do, because that's what we want to do. We do help states get started and do this in their state and, let them go and do it. So we are happy to help startup states. You can go to the Facebook page, which is facebook.com/enforceicc, or heroesforchildrensrights.org is the website. Or you can email at respectfullypac@gmail.com. And we're on all the time. Mm-hmm.
Great. And this is for the listeners who are jogging, exercising, or doing the laundry while they consume the content. But I also tell the viewers they can go into the description portion of this video where you will have the contact information and people can learn more about you. Well, Rael, pleasure to speak with you. Thank you for sharing this helpful content and being a guest on the Law Center videocast.
Thank you. Thank you so much for having us and sharing this info.
We've been here with Rael Lapenta, and I am your host, Larry DeMarco. Thanks for watching, and don't forget to subscribe, share, like, and comment, and click the notification bell next to the subscribe button to be alerted of new videos. Check the description portion of this video where you can learn more about Rael Lapenta, the Interference with Custody Coalition, and our revolutionary Family Court Custody Boot Camp, which will forever transform child custody court, one self-represented litigant at a time. And also sign up for our free ebook, which has free resources for self-represented litigants and discount on items in the Law Center store. Signing off. Tune in next time. Bye for now.